defining a term you used earlier, Steve, which was marital property. So can you talk a little bit about the distinctions between marital and separate property, and from my perspective, how important that is as you go through the process vis-a-vis the financial consequences of a divorce?
Sure, Robert. The distinction is that marital property, and these are all generally speaking, they can find an exception somewhere in the case law, but generally speaking, anything that is acquired during the marriage through marital efforts and labors. So something that after a couple gets married, they go out and purchase, that's marital property. Something that is acquired with your earned income during the marriage, that's marital property. Something that is purchased with funds that came out of a joint account, that's marital property. Marital property in Georgia is subject to what's in this state called equitable division. If the parties can't themselves settle out on who's going to get what, Mike gave the reference to, it ended up being 99% what they as individuals recommended, then the court will settle it out. The court is empowered to divide marital property. So your question as to what is separate property, I could say that's everything else, but what everything else means is it's what did you have prior to the marriage? What did you bring into the marriage? And then what did you keep separate? If a person gets married and they have $100,000 in the bank, and then that would be separate property. If after getting married they deposit that into a joint account that gets commingled with both people's direct deposits from their earned income during the marriage, we've just transmuted that into marital property. We've transformed it. Also, something that you would inherit from a relative during the marriage, that will be separate. Again, so long as you don't then commingle it with marital property. Gifts that are directly to you during the marriage, that will be separate property.
Robert, if I could add
Absolutely.
on, just add a level of complexity to what Steve just talked about.
Or you want to complicate it? Okay, Mike.
Absolutely do. There are assets that are considered both marital and separate, and what I'm talking about is a simple thing like a 401k. Somebody comes into a marriage and they're at the same job while they get married. They had a balance of, let's say, $100,000, using Steve's example, in their 401k. They get married and they continue to contribute during the marriage to that 401k. And then they file for divorce. Well, from what we do is we show part of that asset, the $100,000 plus the growth on that $100,000 over the course of the marriage, is considered separate property. And that becomes a pretty lengthy calculation. And a lot of clients don't understand that. Why isn't that whole thing marital property, or why isn't it separate property 100%? Because I started this and contributing before I got married. The same thing could be said with other assets, stock options, another level of complexity there, where options are earned but may not vest until after the divorce. And there's calculations there we call coverture calculations, where we have to carve out the marital portion and then the non-marital portion.
Houses, don't forget houses.
And houses also. So there are complications to assets, and everything is not as simple as things might appear to be on paper.
Right. It seems to me, hearing all three of you speak about this, that what may happen conceptually is someone puts together JoAnne's brain book, and then Steve and Mike need to figure out, and sometimes, as you say, with very complex financial calculations and an understanding, maybe looking back where the funds came from, what happened to them, so on and so forth, then try and sort out what goes in what pile, marital or not marital, and sometimes, as you say, an asset may be a little bit of both.
Right. In a perfect world, I think both Steve and I, if I could speak for you, Steve, would love it if our clients came in with JoAnne's brain book. Unfortunately, typically it's a laundry basket full of documents, and we're putting things together for them.
Well,
Let's throw one more term into the mix, community property. I know that Georgia is not a community property state, but what if you're a Georgia resident and you happen to own maybe a vacation home in a community property state? What does that do?
I think the solution there, Millie, is that the property that's located in a community property state will itself be subject to community property. And though I went to law school in Louisiana, which is one of the 8 community property states, I'm not going to speak to community property. I took the common law courses. I knew I was going to be moving on. But the thing to do there is for your local counsel or your local coach to contact someone who is a community property lawyer, most probably from the state where that property is located, and associate them as co-counsel, because that will be one element of property that will be controlled by the state in which it sits. Just as if people were married in a community property state, but if they've been in Georgia, a non-community property state, and this is where they're getting divorced, this is where the law will apply to them, and generally speaking, it's not a community property divorce with the exception of that property.